by accepting appointment as an assistant professor with plaintiff's Department of Obstetrics and Gynecology, which also functions as a practice group. Defendant agreed not to practice medicine within 30 miles of the city of Albany for a period of 5 years after leaving its employ. 5 years later, although defendant's income had doubled in the interim, the parties were unable to resolve defendant's complaints concerning his compensation and the facilities and staff provided to him, and he resigned to open his own practice nearby. In response, plaintiff commenced this action seeking to enforce the restrictive covenant and removed for a preliminary injunction during the pendency of the action. Defendant cross-moved to enjoin plaintiff from enforcing the covenant, alleging that he is the only fellowship-trained physician in the Albany area who can treat conditions within his subspecialty, urogynecology and reconstructive pelvic surgery, and that plaintiff's breaches of the unemployment agreement bar its enforcement of the covenant. Supreme Court granted plaintiff's motion and denied defendant's cross motion, prompting this appeal. It is well established that such a covenant will be enforced if it is reasonable as to time and area necessary to protect the employer's legitimate interests, not harmful to the public and not unduly burdensome. Also, our review is limited to determining whether the lower court's discretionary powers were exceeded or, as a matter of law, abused. Furthermore, a motion for a preliminary injunction need not be denied even if there is an issue of fact as to a necessary element. Instead, the trial court is to determine by hearing or otherwise whether the requisite elements are present. Initially, we cannot agree that Supreme Court abused its discretion by resolving the issue of whether the public would be harmed in plaintiff's favor without conducting an evidentiary hearing. While defendant's submission arguably raised an issue of fact as to whether he is the only fellowship-trained physician who provides treatment for all of the medical conditions peculiar to his subspecialty, he failed to effectively dispute the assertion by Barry Cogan, chief of Plaintiff's Division of Urology, that all of the conditions listed by the defendant can be treated by members of plaintiff's staff, that with only one exception, the procedures performed by defendant are also performed by Dave Das, a board-certified urologist, and that Das performs an alternate procedure for the condition treated by the one procedure unique to defendant. None of the physician affidavits submitted by defendant states that Das does not or is not qualified to perform those procedures, nor can we agree that plaintiff's alleged failure to provide adequate staffing and compensation preclude it from enforcing the restrictive covenant in view of defendant's continued performance of the parties' agreement. A party to an agreement who believes it has been breached may elect to continue to perform the agreement and give notice to the other side rather than terminate it. When performance is continued and such timely notice is given, the non-breaching party does not waive the right to sue for the alleged breach. However, by choosing not to terminate the contract at the time of the breach, the non-breaching party surrenders his or her right to determine later based on that breach. Although defendant complained in writing about the alleged breaches, the plaintiff over the years, there is no dispute that he chose to continue to perform under the contract. In his letter of resignation, defendant stated that it was plaintiff's failure to agree to underwrite his plans to open a clinic of his own rather than any current alleged breach that was the reason for his resignation. Thus, while defendant may not have waived the right to sue plaintiff for past breaches of contract, he did waive his right to terminate the contract based on those alleged breaches because he continued to enjoy a substantial income and other benefits from his employment after they occurred. Thus, Supreme Court's denial of defendant's cross motion was proper. Finally, we agree with the Supreme Court that the plaintiff also demonstrated a strong probability of irreparable harm if the preliminary injunction were denied. For plaintiff likely would lose the investment it made in hiring defendant and establishing the specialized practice for which he was recruited. It would lose patients and revenues to defendant's new practice, and it would have difficulty in recruiting a replacement physician if the defendant were permitted to compete in violation of his covenant.
It's okay.
You're getting good speed on this stuff. It was, should tell you how fast that was. 16. $185. Want to read some?
Yeah.
That would give those guys who take it over to do the thing a run for their money.